My name is Chantrell Williams. I am the director of the Custody Advocacy Program here at the Council for Children's Rights. And I'd like to introduce our team. I'll let them introduce themselves so that you'll know who they are.
Okay. Hi, I'm Ashley Neal. A little bit of background, I started volunteering for CFCR in 2009. I was doing corporate bankruptcy work at the time. Kind of got hooked on these cases and started working here full-time last October.
I'm John Parker. I'm a staff attorney at the Council for Children's Rights. Been here since 2007. Looking forward to working with all of you.
Hi, I'm Laura McCready. I'm the newest member of the team. I started volunteering here this past summer, and I joined as a part-time staff attorney in September. And prior to that, my experience was mostly in federal court.
All right, thank you. So I've been here about a year and a half, and I started also as a volunteer attorney before I came to the council. I am the director, like I said. And so we just want to tell you a little bit about, well, first of all, thank you for coming here. We appreciate your time and you volunteering and agreeing to advocate for children. We have a lot of cases that we take on every year, and so we cannot do what we do without the volunteers. Literally, and I mean that sincerely, that you provide us with extra set of hands that we need to advocate for children. And in the Custody Advocacy Program, we advocate for children who are caught in the middle of high conflict custody cases. The judges in family court appoint us to represent and advocate for those children. And so on each case that we have, we work with volunteers. There's two volunteers assigned to every case, a volunteer attorney and a volunteer custody advocate. So we work as a team together, and we are sort of the feet on the ground to really help the judges to make the decision in terms of what's best for children. So a little bit about the Council for Children's Rights. We are a nonprofit agency. We have 3 direct advocacy teams. We have the Children's Defense Team. That team represents children in juvenile delinquency matters. Every child that's charged with a crime, the Children's Defense Team represents that child. So we're essentially the public defender for children in Mecklenburg County. We also have the Individual Advocacy Team, and they advocate for children in educational settings, mental health issues, making sure that those children have the resources and the resources that they need in terms of education-wise and mental health issues. And also there is the Custody Advocacy Program, which is why you are here. And so we thank you for your time and your willingness to serve. So this is hopefully not just about us using you to get work, but we're hoping that you are fulfilled in your experience as a volunteer, and that you walk away from this really understanding that your work makes a difference. And I think we're going to have the judges come over later in the afternoon during the lunch session. I think they will echo the fact that what you do matters, and it really makes a difference in the life of children. So thank you for your time, and we're going to go ahead and get started with the presentation. It's going to be a very long day, so just want to let you know that on the other side of the table, the room, there is drinks and muffins and things. If you want to sort of get up and step out, use the phone, you're welcome to do that as well. We are recording the training today as well, just to be aware of that. Okay? All right, so we'll get started. So we're going to talk initially about just, what is it that you're going to be doing? What is the Custody Advocacy Program, and what do we do day to day? And throughout the day, you'll hear the term CAP, and CAP is just an acronym for the Custody Advocacy Program, which is what we do. So we're just going to go through and just sort of talk about the ins and outs of what it means to be a volunteer on a CAP case. And I'm going to show a video initially, and we're going to talk about that.
A lot of things I didn't understand. A lot of things I'd do different if I could.
Can y'all hear that?
It's like I think there's a lot of things you wish you could change. I can't. Some things once they're done can't be undone. My wife, my ex-wife, says that she loves Billy. I believe she does. But I don't think that's the issue here. If I understand it correctly, what means the most here is what's best for our son, what's best for Billy. My wife has always said to me, why can't a woman have the same ambitions as a man? I think you're right. Maybe I learned that much. But by the same token, I'd like to know what law is it that says that a woman is a better parent simply by virtue of her sex. I had a lot of time to think about what does it make somebody a good parent. It has to do with constancy. It has to do with with patience. It has to do with listening to him. It has to do with pretending to listen to him when you can't even listen anymore. It has to do with love, like she was saying. And I don't know where it's written. It says that a woman has a corner on that market, that a man has any less of those emotions than a woman does. Billy has a home with me. I've made it the best I could. It's not perfect. I'm not a perfect parent. Sometimes I don't have enough patience. I forget that he's a kid. But I'm there. I get up in the morning, and then we eat breakfast, and he talks to me, and then we go to school, and at night we have dinner together, and we talk then, and I read to him, and we built a life together, and we love each other. If you destroy that, it may be irreparable. Joanna, don't do that, please.
Okay, so what do you think it is that makes a good parent a good parent? Or maybe the better way to say that is, what is good parenting in your opinion? Like, when you think about parenting, what is a good parenting? Anybody? What about stability? Is that important when raising children in terms of who can provide the more stable home? Any other thoughts in terms of what's good parenting? Yes, sorry. Les.
Establishing kind of ground rules and allowing them to explore on their own, but kind of stay within the parameters of some of those rules.
Right, so setting boundaries for children, yeah, that's important.
And, you know, just hopefully developing a relationship to where they feel safe and the ability to be open in what they're doing.
Yeah, so a sense of comfort and stability in being just comfortable in their home setting, and that's important. Any other thoughts about good parenting? Yes.
Being able to smile and put on a good face even when you're completely ticked at the other person.
Yep, that is, yeah, huge. Yeah, that's huge. Yeah, absolutely. You know, Dustin Hoffman's character is talking about what he thinks makes a good parent, and really that, I think, is the issue of what we do. We're looking at, we've got these two parents who are caught in the middle of a heated custody battle. And what happens in that is, although the case is all about the child gets lost in that a lot of times. And so that's where we come in, and we want to provide a voice for that child to say, you know, wait a minute, I know you all are arguing over here and you can't get along, but what's best for your child? And that's really why we're in the case. And so in doing that, we're looking at, you know, in terms of parent A versus parent B, why is parent A better versus parent, not really better, but what about parent A versus parent B is, which parent is better in terms of what's best for this child? You know, is one parent provide more stability? Does the child have mental health issues and one parent is more willing and able to advocate for their child and meet those needs that child has? Is one parent's work schedule crazy that they're maybe working out of town and they can't be there for their son or daughter? So we're looking at sort of what are the issues that kind of makes one parent not really, I hate to use the term better, but which parent is better situated to raise this child? And it's so hard because, you know, you go from maybe a two-parent household to now you got to figure out how is this going to work with one parent over here, one parent over there, and the child's life is sort of flipped upside down, and they have to navigate between being at mom's house versus being at dad's house. And they sense the instability and the contention between the parties, that even if they don't say it, the children, they sense it. And so imagine how that impacts children in terms of the importance of our role and making sure that child in that process is heard. So really this is all about best interest. And here at the Custody Advocacy Program, the attorneys are referred to as best interest attorneys. So what is best interest? I mean, what is that all about? Because that's really the cornerstone or the polar star of custody cases. It's what's in that child's best interest. And the North Carolina law basically tells the court that in order for custody of a minor child, shall award custody of such child to such person as will best promote the interest and welfare of that child. The court shall consider all relevant factors, including domestic violence. In terms of what those relevant factors are, that's all that they tell us. I mean, it gives the example of domestic violence, but I mean, going back to when I asked you, what makes a good parent a good parent, I mean, we kind of just know what that is, right? I mean, I think we just know, even for us like myself who don't have children, you kind of know as being a child of a parent, what makes a good parent a good parent. And so although the law doesn't sort of lay out for us all the sort of factors that we look into, we kind of know what those factors are. And so in doing the work that you'll be doing with us, it's really looking at those factors in each individual case in terms of what makes this parent, in terms of why that parent may be a better fit for this child versus the other parent regarding where that child lives primarily. Any questions? Okay. So more specifically, in terms of going from the general definition that the law provides, the state bar has told us or defined for us what we do and how we're supposed to go about doing the work that we do. And in your packet, there's a copy of the formal ethics opinion 9 that we received from the state bar that sort of lays out what the responsibilities and the role of a best interest attorney is. So I'm not going to go through that, but I would encourage you to, on your own time, to take a look at that, because it's really important to sort of have a sense of what it is that we're supposed to be doing in these cases and what our responsibilities are. Also in your packet, there is the copy of the local rules for Mecklenburg County, and that kind of narrows it down a little even further for us in terms of what the judges here are expecting us to do. The local rules define specifically what the custody advocacy program at the council and what we're charged with doing. So that's in your packet as well. So I really encourage you to take a moment to read through that as well, just sort of get a sense of what the judges are looking for, and also think about the attorneys who represent the parents. That's what they're seeing as well. So that's their expectation, what we're supposed to be doing in these cases. Any questions about that? All right. Yes.
Just a fundamental question.
Mm-hmm.
And if I'm jumping the gun,
They're fine.
So obviously you've got an attorney for the mother, you've got an attorney for the father,
Mm-hmm.
and we're sitting in here trying to represent the best.
I'm sorry, can you maybe use the mics to make sure that your question is recorded? Thank you.
Sorry.
It's on.
It's on? Okay.
Mm-hmm.
So you've got an attorney for the mom, an attorney for the dad, and we're supposed to represent, I guess, the interests of the child. I'm just curious, and again, if I'm jumping, if the child is old enough, how often does the judge get the child on the stand and say, where do you want to live? Or, what's your, and I would assume that would be pretty heavily weighted relative to everything else that's going on. I clearly understand if the child is a baby or something like that. So where does that fit into the? Yeah, I think ideally, I think we're appointed so that children don't have to come to court and say, I want to live with mom versus dad. Because when you think about an older child, they may want to live with the dad or mom because mom's more lenient, or they have more flexibility or more free time in mom's house, and maybe dad's more structured, more disciplined. And it's really, what's best for that child. So we are best interest attorneys, not express interest attorneys. Express interest attorneys have to go about what the child wants. And of course, an older child, we're going to listen to that and factor that into what we think is best for that child, but we're not bound by what the child wants. And so there are cases where a parent's attorney may, bring the child in, or a parent may bring the child in to speak with the judge. And so when that happens, the preference is that be back in chambers and not in open court. But I think that, we're involved so that doesn't have to happen. And hopefully, we want to keep the child as much out of the conflict as we possibly can. Thank you.
Yeah, you're welcome. Any other questions? All right, I'm going to turn it over to Ashley, and she's going to go into more detail about sort of the day-to-day sort of breakdown between the staff attorney, the custody advocate, and the volunteer attorney. Okay.
I know Chantrell, really quickly, I know she's already thanked you for being here. I want to thank you again. You guys are so important. You have no idea how important you are to our cases. So thank you again for being here. First, I want to go over how our team actually gets cases. There are two ways that we get cases. One way is that a judge is going to appoint us by his or her own motion, so ask us to come in because the judge perceives that there are issues that CAP can help with. The second way we get involved is by motion of the parties. So the parties actually go to court, file a motion for CFCR to be involved. I guess the main point here is that we have a lot of parents who call and say, you know, they see the Council for Children's Rights on the internet, they call, they want us to jump in, but it's not always appropriate for us to be in every case. And so we kind of have that filter where the judge has to say yes or no. When CAP gets a case, what do? Well, we get initial information from the parents. It's called a family information form. So just, you know, their basic address, date of birth, that sort of thing. We submit a formal appointment order to the judge. So the judge, initially when we're appointed, it'll be you know, maybe an open court. There might be, they have a little form that they actually keep with them, and it's an initial order appointing us, but we will actually have a more formal appointment order that'll have the CAP attorney, and then it'll have the volunteer attorney's name, and then the custody advocate's name as well. We'll get copies of the court file, so when you get your case at the very beginning, one of the first things you'll get, that'll be the pleadings that are in the case, and that's our, you know, kind of our initial starting off point. We will assign volunteers to the case, and Tanya Farr, who's our program paralegal, she's at calendar call right now. I think she'll be here later, but she actually handles that. And then we'll send the information to the volunteers. And we will, you know, Tanya will initially email you, tell you that you've been assigned to a case. And, you know, one thing I do want to point out, which we will go into later, but, you know, if it's not a good time for you, that's okay. We understand. We understand things come up. There are busier times at work than others, so please let us know. All right. Okay. Once we do all that, we're going to start our investigation. So the first time that you will actually meet with the parents will be here at the office. And we call those the parent interviews. And what that is, it's basically an hour for each parent to come in and tell his or her side of the story, how we got where we are today. So the CAP staff attorney will be there, the volunteer attorney, the custody advocate, the parties. If the parties are represented by attorneys, which I'd say it's probably about 50-50. We have a lot of pro se parties, but we do have a decent amount who are represented by attorneys. Sometimes the attorneys choose to be there. A lot of times they don't, though, because they're familiar with us and the work that we do, and they'll give us a release to go ahead and talk to their clients. So that is an hour they just spill the beans. I mean, you honestly would not believe some of the stuff that comes out during those conferences. So I find that parents tend to be very honest. They want you to know what happened. They want you to know what the other parent did, and they are going to tell you about it. And we often have to cut them off because they probably would stay all day if they had given the option. But so they just kind of, you know, tell us their side of the story, and we interject questions, you know, important things. You know, we'll have looked through the file, so if mental health is an issue, or drugs, or alcohol, or abuse, we kind of know where to direct those questions. So we'll have the parent interviews. So that's everyone, and then after that's over, the staff attorney will order records, and what we do is we fill out a sheet, anything that might be relevant. So if we have DSS records we need to order, criminal background checks, medical records, education, so school records. Sometimes we will order just a recording of the previous court hearing, just anything that we think might be relevant. And so we'll go ahead and order those. As you can imagine, sometimes it takes a while to get those in, DSS records and such. So we go ahead, we get the ball rolling on that because we want to be sure we can get that in a timely manner. The next thing that will happen with the custody advocate and the volunteer attorney, you'll do home visits. And this is always another interesting part of this job. We let the parents know during the conferences that there's going to be a home visit. Generally, they're not surprise home visits. Occasionally we'll do that. I did it in a case where we had an alcoholic mother, and so we needed to, you know, pop in and see what was really going on. But in general, we're not going to do that. So we will let the parent know it's going to be a time that's convenient for you, the staff attorney, and you, the volunteer attorney, and the custody advocate. So we don't want to make that inconvenient for anyone. And what you'll do is you will go to the home, preferably when the child is there, so you can see the child in that environment, see how the parent interacts with the child. And it's kind of your job to look around and look into everything. And we let them know that at the get-go, and let me also mention, if this is a case where we feel like there might be a safety issue, we will talk about that and how to handle that. We never send volunteers on home visits alone. Always good to have a team, just in case, in the event anything should happen. If we think the staff attorney needs to be there as well, we're happy to join you. That's not a problem. So, you go to the home visit, you watch the child, you look around outside, you look around inside, you look at the bedrooms, peek in the refrigerator, see if there's food, see how clean everything is. I mean, you're just kind of looking for anything that might, trigger a thought. If you've got a parent who you think might be drinking, you can go in, you can look in the cupboards, you can see if you find anything. Now, if you go in and you have a parent who's clearly agitated and doesn't want you to do that, don't feel like you have to push the boundaries. I think most of our parents, I would say, want to work with us. They know we're investigating. They know that they want us on their side, for lack of a better way to put that. But so most of them are very cooperative. Chances are, if they're not cooperative, they're trying to hide something, and that tells you something too. So that's something you note as well. So you'll do the home visits. After that's over, we'll do a meeting with the child. Sometimes we'll have them come in here. Well, it depends on the age of the child. Obviously, if it's a very small child or an infant, we won't meet with the child separately. A lot of times we'll have the child come here into the agency. Sometimes we'll do it at school. If the child's more comfortable there. Again, it's depending on the age. We talk to the parents about the child, just in general, their personality, try to get a feel for what would be easiest and more comfortable, and what kind of environment would be conducive to them being more honest with us and telling us what's really going on. As Chantrell was saying, we do take into consideration what the child wants. We don't necessarily follow that request, but we do like to take it into consideration, of course. And then finally we have records review. So the entire team, once we get the records that we ordered way back, once we get those in, we will go through those records. And depending on the case, that can be a time-consuming process or it can be a quick process. Every case is different. Some cases will have DSS records that are this big. I mean, it just depends on what's been going on in the child's life and the parents' lives. We will send those records to you, except for the DSS records. We actually have to keep those here in our office, and we can't send copies out. But we will arrange a time for you to come look at those and set up a conference room for you. You can take your time, look through them, do whatever you need to do on that. So that is kind of the investigation and just the different duties of the VA versus the CA. All right, now after we do that investigation, our big job is to decide what our recommendation is going to be for the child. We need to reach a final position as to what we're recommending for custody. We will talk about physical custody, so where the child actually should live. We'll talk about legal custody, so who should be making the decisions. And there are just all kinds of ways to split this up. I mean, it again depends on the case. I mean, sometimes you'll have joint. You get to the end of the case, it's 50-50. Both parents maybe aren't great, but neither one of them is terrible either. So, and the child loves both parents and needs to be with both parents. Sometimes it's better to have a child. Again, age might make a difference. If they're a school-age child, we get some cases where, one parent's here in Charlotte, so, Mecklenburg's the appropriate place to have the case heard, but we'll have a parent who's moved to, Virginia. Obviously, we can't do joint custody there because you have a school-age child who can't be, shuffled back and forth in between states during the school year. So, all kinds of things like that come into play. And really, most cases are going to have, I don't even know, but many, many, many factors that you have to consider and just put everything together and think, okay, what's best for this child? What happens when the team does not agree on what's in the child's best interest? Part of the reason we have a team is because these are hard cases. These are hard cases. There are bad things happening to these children, and we need 3 heads with 3 backgrounds and 3 different perspectives and 3 different opinions to think through what is actually best for the child. I find that often a lot of times the teams are on the same page. I've had a very rare case where, you know, we just completely disagree. If there is a complete disagreement, you know, it's actually the lead attorney will make the final recommendation. But again, I find that's very rare. And remember, we are just making a recommendation, so ultimately it's going to be up to the judge, which I'll go into as well. So once we come to what our recommendation is going to be, a lot of times we'll communicate that to the parties. If we've gotten to a point, you know, these cases can take, and this is another thing to let you know, these cases can take anywhere from, you know, let's say 4 months to a year. We've got some cases that have run longer than that. Sometimes it's just because circumstances are changing with the parties, we need to continue investigating. A lot of times it's hard to get on the court's calendar, so we'll have a case set, but it'll be rolled over and rolled over. They are just inundated, family court is, with cases right now. And so, you know, we do the best we can to get it on the calendar, but it's not always an easy thing to do. But once we come to our position, we'll communicate that with the parties, and if everyone by this time is kind of on the same page and we get the feel that maybe mom and dad are starting to get along, or maybe the temporary order that's in place is working for them, or maybe we could make a few changes here and there, we will offer to talk to the parties and try to do a settlement conference here at the council. So we'll do that. We'll come up with an agreement that's, that both parents are willing to sign. Once that's done, we'll send it off to the judge, who still, again, has the final approval on the order. And that's, of course, the less contentious way to kind of resolve a case. I always think, you know, in the long run, it's better for the parties to come to the decision themselves rather than having a judge say, this is what you're doing, and then it's, you know, a little more contentious. So that's one way to do it. The other way to do it is that we set a custody trial. Like I was saying, we get back on the court's calendar, we go in there, and we go in front of the judge. And we actually have, in the courtroom, the judges have been kind. So the plaintiffs, you know, they have tables for plaintiff, table for defendant, and we actually have a little makeshift table that's kind of like one of these for CFCR in every courtroom. So we go in there, and you know, we have our own witnesses, we have our own evidence. We do kind of exactly what the other parties do, and what we do is we recommend to the judge what we think is in the child's best interest. It's not, the recommendation is not binding, again, on the judge. The judge has the final decision, but obviously it carries some weight because we've been out there looking at what the judge can't see from behind the bench. And when the custody trial comes, what we do, we all meet, we prepare for trial, we go over, you know, what exhibits should we have, and what witnesses should we call, and do we need to subpoena anyone, and just like we're preparing for a normal trial. So as far as the volunteer attorney's role in the custody trial, it depends. You know, we have a lot of volunteer attorneys who do corporate law, and they want nothing to do with examining witnesses, and that is fine. That is completely fine. We still value your time. Sometimes we have family law attorneys that are volunteering, and this is, you know, this is kind of what they do every day. And so they want to examine witnesses. So, you know, sometimes we'll split up the witnesses, or, you know, we just kind of want to see, you know, we want you to get through a couple of cases before you really start doing that. But you know, once you're comfortable with it, it's definitely something, you know, we want to talk to you about and see if you'd be interested in. The custody advocate is going to testify. If we go to trial, chances are the custody advocate will testify. So that's something, just to let you know, some people find that intimidating, and I understand that. You know, you're in a courtroom and you're testifying. I think that our volunteers, and we'll have a volunteer panel later, and you can certainly ask them about it. I hope that what they will say is that, you know, they enjoy getting the voice of the child out there and letting the judge know what needs to happen in our opinion. You know, in general, if other attorneys are in the case, are you going to get, you know, grilled on the stand? It doesn't really look great to, you know, try to tear a volunteer apart up on the stand. I'll say that. It's just, you know, the judge is going to notice that. I'm not saying that it would never happen, but we try to be well prepared and, you know, have you prepared for any questions that you might have. And on that note, we actually have a lot of volunteer attorneys, not a lot, but some who actually prefer to be the custody advocate in the case because they want to testify and they like to testify. So that's also an option as well for any volunteer. If you're an attorney and you'd rather, you know, for a case or two or however many, for every case, if you want to be a custody advocate, you're more than welcome to be to sign up for that role as well. And as I've been saying, so the judge will make the final decision. And sometimes the judge will call us back, but usually it's done, you know, right there while we're sitting in court, right after the trial. And once the judge gives the decision, we will come back and prepare the order and then submit it for his or her signature. I'm trying to think. Yeah, I'm gonna leave that at that. Okay. Oh yeah, go ahead.
I was curious about the DSS records being, you have to keep them here. Are can they be introduced into evidence in the trials?
Yes, yes. We can still issue a subpoena. We can have subpoena the records to the actual trial. We can also, I have a case right now that's just a terrible, terrible case, and I have a DSS worker who has been working closely with me the entire time, and we've actually been to court 3 or 4 times now. And every time I have simply sent him a subpoena, he's waived service and signed it, said, okay, I'll be there, and he's been there. And he's been very, very, very helpful. I can't say that they're all as willing as he has been, but we can subpoena them there and get the records in that way. Yeah, yeah.
For when you do the home visits,
yes.
It's typical to, when you do the home visits, is it typical to take pictures and then admit those into evidence?
You can take pictures if you want to. What I would say, though, is kind of gauge the parent. I have actually, you know, when I was a volunteer, I was saying for 4 years I was a volunteer, I never took any pictures. You know, if you think, and I'll tell you, I was actually on a case with a volunteer where we ran into, Chanterelle smiling, an issue where the volunteer was a little too insistent on trying to take pictures, and the mother got very angry. So, you know, if you see something you need to take a picture of, I would say it's best to ask, because pictures are a little, you know, it's one thing to come into someone's home and just, you know, look around and, you know, we're kind of being nosy already, but to take pictures, that can be offensive and it can kind of escalate things. And keep in mind, you're still observing, you know, what's going on in the house, and so when when the custody advocate goes to court and testifies, you'll be able to say, I saw this. You know, I saw an open container of alcohol. You know, we think the parent's an alcoholic. I saw an open beer can. I saw a gun sitting out that, you know, with no protection that was in reach of the child. I saw drugs on the, gosh, let's hope this doesn't happen, but stranger things have happened. You know, I saw drugs sitting out on the counter. So even if you don't have a picture, you'll be able to testify to it. Right? Yeah.
You talked about DSS. Do we share cases that a guardian ad litem is also assigned to?
Generally, we don't.
Okay, so once the, and I may be wrong here, but once the case goes to DSS, isn't it North Carolina law that a guardian ad litem has to be assigned to that case?
Yes.
Okay, so if we're dealing with DSS, that means that the child may be in DSS, which means that there's a guardian involved, and how do we interact with that situation?
Well, now a lot of the DSS cases that when we are appointed by the judge, it may be that DSS is already involved, but the judge wants us in the case, as opposed to a guardian ad litem. And Chanterelle may be able to speak better to this than I can.
We're involved in the case, and DSS has investigated allegations of abuse, but they haven't taken custody of the children. And so it's still a family law case and not a juvenile court case. And so, but if DSS does take custody of the children, then you're right, a GAL is appointed, and we kind of step aside because we don't really have the authority to act in the juvenile case. Sometimes we'll stay in the case just to sort of be a resource to the judge and the court if they need us, because we've been involved in the case up until that point, but we just kind of step aside at that point.
So then an option isn't necessarily, if we're dealing with it, and let's say there's one parent that's, well, let me back up, fundamental question too. So all of the cases that we get involved with, there is an active desire for a mother and an active desire for a father for custody of the child.
Yes.
Okay, so that eliminates a whole lot of questions. Okay.
Okay.
Because one of the options would be to leave it leave the child in the custody of DSS, but that's not when we're.
Yeah, when we were appointed, it's just a family law case where a mom versus a dad.
Gotcha.
So with DSS is not taking custody of those children.
Okay.
So that's a separate juvenile court proceeding.
Thank you so very
You're
much.
welcome.
For that. Really appreciate it.
And we'll have time for more questions at the end as well, so feel free to keep thinking of those. Do's and don'ts. Do keep your team members in the loop. Check your email often. These teams really need to stay on top of things. I was saying earlier, we have a lot of cases, and we kind of have to push to get them through the investigation and then through the court system. And so, we'll have things that come up, and I'm not saying that Sunday morning you need to get up and check your email first thing to make sure that nothing's happened. I'm not saying that at all. But just if the lead attorney or a staff attorney emails you, just be respectful and respond in an appropriate amount of time. Or if you're the CA and the VA, a lot of times those two communicate between each other. You're trying to arrange home visits, or you're trying to do school visits, or what have you. So just be respectful and remember that everyone's time is important, and respond as promptly as you can. Do complete all aspects of the investigation in a timely manner. And again, I just mentioned that sometimes these cases can take a long time. What we generally try to do, after we have the parent conference, within the next 60 days is when we try to get, the home visits completed. One thing I just realized that I didn't mention, collateral calls. I don't think that was on the PowerPoint. Another thing that the CA and VA do right after the parent conference, we call collaterals. So when the parents first fill out their forms for us, the very last page they will put friends, family, people they want us to talk to, just about them in general, about their relationship with the child, that sort of thing. And so the CA and VA actually make those calls. Sometimes they split them up. Sometimes, one person will do mom, one person will do dad. Sometimes they'll mix them up just to get two different perspectives. In some cases, the custody advocate will make all the calls. I've had some cases where they want to do them together, and I'll reserve a conference room upstairs, and the CA and VA will just come in and try to knock them out, in an afternoon. So that's an option as well. But it's an interesting way to get some insight into the parties and how they get along, especially. Yeah, sure.
Can we make calls on people outside of the collateral list?
Sorry.
For instance, if in our investigation somebody mentions a priest or a rabbi.
Sorry.
A priest or a rabbi or something that's not on the list, are we able to go visit with those people? Or?
And what I generally do in a parent conference, if there's a name that comes up and we think, oh, we might want to talk to that person, I'll say, can you give us the contact information? And the same thing goes throughout an investigation. If you are talking to the child and the child mentions something about, so-and-so is my teacher, and I love this teacher, and I talk to this teacher, yeah, we can go to the school and talk to that teacher, and just anyone that, might be relevant. And again, if they mention someone and we ask for contact information and they say no, that's another red flag. I mean, that's another, if they say so-and-so is my best friend, and we say, well, can we have that contact information? And they say no, that's something to note. Even if you're not talking to that person, that's still something to note.
But if they say no, we cannot talk to that person if they say no?
Well, that's not necessarily the case, but I don't know that I'd go. I think that's very case specific, and we'd have to sit down and consider how helpful that information might be versus, what it might do to anger the parent. So I think that's a very case specific question, and we just kind of need to see how helpful that information would be.
Thank you.
Okay, sure. Let's see here. Do submit written summaries of the collateral calls and home visits. It is very helpful for the staff attorneys once those home visits are done and the collateral calls are made to just type up little summaries of what you've heard. You guys know as well as I do that if you have a call with someone, you'll remember you know, bits and pieces, but you're going to forget some of the details eventually. And for the cases that run a long time, especially, we want to make sure we have those in writing. We'll put it in the file here, and so we'll, you know, when the trial rolls back around, we'll be able to go back and look at everything. Do you ask the CAP staff attorney when you're unsure about something? So like the question you just asked, you know, should we call so-and-so? Again, you know, we'd sit down, we'd evaluate, you know, where we are in the case. Is that really a necessary thing to do? If you're just unsure about anything, ask us. You know, if there are other attorneys in the case, you know, usually we will handle that communication. But if you're unsure, if you have a question like that, you know, well, I'm the volunteer attorney, should I be communicating with that person? Ask us, and we'll help you through that process. So never worry about asking us a question. Again, these are difficult cases, and things come up that you wouldn't expect. Do you understand that your presence is absolutely crucial if the case goes to trial? So prior to the case actually getting scheduled, a calendar call will come up, and that usually happens, I'd say, about 3 to 4 weeks before a term would actually begin for a judge. And so what will happen is we will be on a long calendar, a list of cases, and Tanya Farr, again, who you'll meet later, she will actually email you and say, what is your availability from this date to this date, and usually it'll be a 3-week period. And so if you're an attorney and have a trial, or if you are on vacation, or anything like that, you can let her know, and when we go to calendar call to actually schedule the case, we'll knock out those dates if possible. Because we want to make it convenient for you guys as well, and we know you have day jobs, so we don't want to drag you away from that. But you know, once the case is scheduled, and this has happened, I think probably to all of us, we'll have a case that's scheduled, and then all of a sudden we'll have a custody advocate, you know, say, oh wait, I think we're going to take a last-minute trip. And the thing, that just can't happen. You know, once it's scheduled, of course, if there's an emergency, we understand. People get sick, things happen. But you're so crucial to the case that we really need to have you there. You're really our primary witness. You know, we examine the mom and cross-examine the mom and the dad and you know, any other witness that's there. But you're the one that's done the home visits. You're the one that's talked to the parents, and you know, maybe multiple times. You know, some parents are more active than others in cases. Some cases are very quiet, and you know, the parents, we get appointed and they say, okay, and they go through with, you know, what they need to go through with the home visits and the parent conferences, but other than that, you're not going to hear from them. Some cases, you're going to hear from the parent every other day, and those are the cases where, you know, you can just if the email comes to me, I just politely email back and say, thank you, I will add this to your file. Because you will have some parents who want to talk to you on the phone every day, and they want to tell you what the other parent is doing that's terrible every day. And we have too many cases to do that. So, and to be quite honest, a lot of the things they want to tell you aren't necessarily relevant to who is better suited to be the parent. It's really just, I want to tell you that I don't like this person. So we have to keep those calls to a minimum. And we don't want you, like I said, waking up on Sunday morning and getting calls like that and feeling like you need to answer them. So again, very, very case specific. You just never know what you're going to get at the beginning. Okay, I think I said this earlier, don't ever conduct a home visit alone. We don't want to put anyone in a position where you feel uncomfortable, where you feel like there might be a safety issue. I will tell you that I personally, you know, for the most part, I've done home visits, I've done plenty of them. The parents are nice, they're welcoming. You know, if you get a parent that you get there and they're kind of, like I said, a little bit standoffish, don't feel like you have to stay a long time. You know, just talk, I mean, if you're going in the bedroom, they're standoffish, just say, okay, well, let's talk in the living room. Don't ever put yourself in a position where you feel uncomfortable. And if you feel like, you know, this just isn't working, you need to leave, that's okay too. And what will happen is when trial comes, there's a reason you're going to feel uncomfortable. So when trial comes around and you're up there on the stand and I'm asking you about the home visit and say, you know, well, you only stayed 5 minutes. Why is that? And that's when you tell the judge, this parent did this, this, and this. You know, that's not an environment I wanted to be in, so we can't recommend that a child be in that environment. So one way or another, it's going to come out what's actually going on. Don't give legal advice to anyone. So we represent the children. We have the parents, they come in, we interview with them, we have no confidentiality with them. That said, these cases, when you take them, you know, we have the team. It's a private, safe place. So don't, you know, go out, talk about the case, tell everyone what's going on, mention names. We ask that you know, keep that within the team. You know, as far as the child goes and what the child tells us, so the child is technically our client, and which means there's a confidentiality there. And so when they tell us stuff, we keep that confidential, unless what a lot of us will do right before trial, if there's stuff that we want to try to get in that the child has said, we will talk to the child about that, especially if the child, you know, is older, and say, do you mind if we tell the judge this? And we will get, it's just like waiving attorney-client privilege with an adult. Do you mind if we talk to the judge about this? And the child will say yes or no. If the child says no, then we respect that, and we keep that within the team. Oh, I just went over the next one. Okay. And then the last one, don't become too personally involved with a particular parent or the child. It's tough in these cases not to want to try to fix everything. You're going to have kids that need things for school. You're going to have kids that need, I was a volunteer attorney on one case, and the custody advocate got so emotionally involved, which in one respect is just, it's great because we know that you're trying to do what's really best for the child. But you also have to keep your distance, because you have to remember that you're going in, you're starting out as the impartial third party. Eventually you're gonna, you know, you're gonna have a recommendation. But these cases can be really hard, and if you're going home every night and it's just weighing and weighing and weighing on you, that can affect your decision making. So, and I'm not saying don't get to know the child, play with the child, I'm not saying that, but you know, if mom and dad will fight about everything, right? So they're fighting about so-and-so should buy the soccer uniform this time. That's not something we get involved in, but a lot of times we'll have custody advocates who care, and they're doing this because they care, but they want to go in and they want to help fix it and decide who should buy the soccer uniform, and that's just going a little too far for what we're doing. We're just making a custody recommendation. So keep that in mind, and don't feel, you know, sometimes the kids need counseling, and we'll give them recommendations. You know, here's a number you can call, or here's something you can do about that. But when it comes to, you know, the little stuff, as much as you're going to want to fix it, just try to remember, you know, your role and what you're here to do, and focus on that. And I think, let's see here. Oh, helpful hints. Okay, sorry, I saw our next speakers are here, so I wanted to make sure I was on time. Dealing with confrontational parents, if you have a parent, you know, we kind of talked about the home visits. If you have a parent or parents who are just confrontational, they are just at you, they are going at you, refer them to the staff attorney. We'll talk to them and we'll take care of it. So don't ever feel like that's something that you need to deal with if you've got a parent that's being overly confrontational. Interacting with parents' attorneys, I mentioned this a little bit. For the most part, we will handle that. You know, again, it'll depend on the case. Like I said, sometimes we have family law attorneys who are volunteers who are kind of used to dealing with some of these attorneys. And they'll do a little more of the communicating, but again, very case specific. Talk to us about it, ask us about it, we'll figure it out. And then knowing your availability. So I said at the beginning, if if Tanya emails you and says you've been assigned to this case, if it's a busy time for you and you can't do it, that's fine. Just let us know. Don't feel like you're letting us down. We would much rather you take a case that you want to be in, that you have time to be in, that you can do a good job in, than feel like you're forced to be in something. So with that, are there any more questions? I think we've got about 5 minutes. Yes, ma'am.
So you talked about settlement conferences and like possibly settling cases without a trial.
Mm-hmm.
Is there ever any point where mediation is utilized in these custody cases?
Well, we get these cases, we're supposed to get these cases after the court has already ordered the parties to go to mediation through the court.
Gotcha.
And we usually get the cases when that has not worked out. So it's very rare that we get a case before the parties have already attempted to go through mediation. Yeah. Oh, sorry. Go ahead.
So what happens in a case where you've done the investigation and everybody puts their head together and both sides are not the right place for the kid? I mean,
that's tough. That's the tough question. And that happens. I will say, you know, sometimes we have cases where there's A and B and there's no C, and there needs to be a C and there's just not. You know, we do the best we can. We make the best decision we can, and we can tell the judge that. We can say, look, this parent is doing this parent is doing this, judge, this is what we've come up with. You know, as far as putting the child into DSS custody, rare circumstance. I mean, there needs to be something just terrible going on. And that we have actually discovered and that we actually have proof of, not just allegations, because I will warn you, you know, you'll go into a lot of parent conferences, sexual abuse, parents love to throw that term around. Love to throw that term around because they think it makes the other, as soon as we hear it, a red light's gonna go off and it makes the other parent look bad. And I hate to say it, but I'm at the point where I go into parent conferences and I say, you know, of course I make a note of that, but okay, you're gonna have to prove that to me, because parents love throwing that term around just to make the other parent look bad. Now, do we investigate and make sure that's not happening? Absolutely. But, you know, it's mental health issues. We have parents that love to come in and say, Mom's bipolar. Yep, Gerald just said it too. Mom's bipolar, Dad's bipolar. He needs a mental health evaluation. He is just crazy. He cannot raise this child. And so our job is to get to the bottom of that, figure out what's actually happening. You know, the parents have constitutional rights as parents, and so you will walk out of cases going, gosh, I wish there was another party. I wish there was a grandma or an aunt or, you know, somebody else that could take the child, but that's not always the case. So, yeah.
Just leveraging off of what you just said.
Yeah.
In our investigation, if we're at the point where we don't believe either party is the appropriate party, can we continue that investigation into a grandmother or into a grandfather or into an aunt or an uncle, whereby we can at the end of the day say, this is a better, because again, if the child is our client, you know, I'm not sure going, well, this is the best of the worst scenario is really in the best interest of the child versus an aunt or an uncle or something like that.
Well, now when we say best interest, though, we're looking at best interest in a custody cases with the parties that are involved. So there's actually statutory law for grandparents as to when they can intervene. For example, there has to be an ongoing custody battle. So let's say we have two parents that are separated, but they are, you know, both they're switching the child over every week, and they're still taking care of the child. Grandma can't just run in and file something in the court and say, I want the child because I don't like what the parents are doing. So we can't, you know, we can't just bring in other parties, but a lot of times we will have grandparents that intervene when there's already a custody battle going on. I actually had one yesterday that settled, and you know, the grandmother will come in and say, you know, statutorily, I can intervene in this case, and I want some sort of visitation, or I want custody, et cetera. Can we go out and just look for people? No, we can't. We're looking at, again, these parents have constitutional rights as parents, and we can't just take the child away and, you know, give it to another party. Even though that's, like I said, sometimes what we would like to do. We just can't do that. That's really not in our arena. So, any other questions?
So for the child's consent, if they tell you something that you want to tell the judge, do you get that consent in writing typically, and does the child really have capacity to give consent?
We generally don't get it in writing. It's generally just, you know, do you care if we tell the judge this? And as to whether or not they have capacity, again, we're looking at, we will have been in the case for a long time at this point, and so we'll know the child. We'll talk to the child, and again, age is a factor. We'll have to look at that. There's really no bright line rule because some children are more mature than other children, so it really, again, I know I've said this a lot, but it's a very case specific sort of decision.